Hello, good afternoon. How are you doing? Okay. So all these machines, I feel like I'm flying a plane. Good afternoon, welcome. Thank you for coming on Friday afternoon. It's not the best day, but it's a great day to hear about torture. So on behalf of the Issam Fares Institute for Public Policy and International Affairs and the Prince Alwaleed bin Talal bin Abdulaziz Alsaud Center for American Studies and Research, we're very happy to have Lisa Hajjar come back. She was with CASAR last year, teaching here, and is leading an IFI Lund University combined project on human rights in the Arab world. She's the author of 2 books. I'll tell you the titles. The first one is called Courting Conflict, a study of the Israeli court system. It's very interesting. I'm going to read that. I didn't know they had a court system, so I shall read that. Secondly, the second book is called Torture, a Sociology of Violence and Human Rights, which was from Routledge in 2012. She's working on a book now called Lawfare. And if you're interested in this book called Lawfare, I recommend that you go to the IFI website and download for free a research report that she did earlier this year in January called Lawfare and Armed Conflict, comparing Israeli and US targeted killing policies and challenges against them. So this is freely available at the IFI website. It's my pleasure today, therefore, to invite to come and give us her talk from the University of California, Santa Barbara. Nice, warm place, except maybe not now. She's a professor of sociology, and her title of her talk is Classified Memories, Trying to Try Terror Suspects Who Were Tortured by the CIA. Good luck. Yeah.
Thank you. It's a pleasure to be back at AUB. I love this place. And thanks to the Issam Fares Institute for inviting me back. The talk I'm going to be giving today, I'm going to begin with basically a broad but quick overview of how the United States became a torturing government and the implications of that, and then sort of zoom in in the latter part of my talk to 2 cases that are going on now or in the pretrial stages at Guantanamo in the military commissions, each of those cases involving people who were tortured by the CIA. So just to give you a sense of how the talk will proceed. And this talk builds on research that I've been conducting really since 2004, really, and primarily looking at the role of lawyers and the law, and particularly those lawyers who have challenged torture. So that's a big part of my talk today. So I realize this is a large amount of words, but let me just summarize some of the crucial events that occurred in the immediate aftermath of the terrorist attacks of September 11th, 2001, which really lead to the United States' decision to officially authorize and utilize torture. In the immediate hours or perhaps days after the 9/11 attacks, President Bush secretly authorized the CIA to engage in kill or capture operations anywhere around the world. And some days later, Congress provided an authorization for the use of military force, which was essentially the domestic American legal license to engage in a global war. Now, the war, of course, began in Afghanistan, and ground troops hit Afghanistan in the middle of October, and before many people had been taken prisoner. There had been some hundreds were starting to be arrested in late October, early November, but before there was many people in U.S. custody, President Bush issues a military order, an executive order, in which he decrees that people, essentially those who are taken captive by the United States, the enemies against whom the United States is fighting, would be characterized as unlawful enemy combatants. And then he briefly elaborates in this military order. But the important element of this was that he more or less invented a completely unknown and non-existent category under international law. Because under the laws of war, when there is war, all people are divided into two kinds, combatants and civilians. So even terrorists would be civilians. But in designating this unlawful combatants, he basically asserted that these people could be held incommunicado, meaning no access to lawyers, no access to having their cases reviewed, no access to any sort of communication beyond their captors. And they would not have any of the rights of either prisoners of war or civilians. In this military order, he also announces the creation by himself, executively establishing military commissions where some people would then, in the future, be prosecuted. Now, within the government, there was a bit of a debate in the fall of 2001, sort of what to do, how to really proceed with the capture and, more importantly, the interrogation and detention of terror suspects. In a war like this, in an unconventional, asymmetrical war, intelligence gathering is a very essential thing because the United States is fighting against, unconventional forces. And the most important and, not necessarily unlawful, in fact, lawful way of gathering intelligence is through interrogation. So interrogation is not per se unlawful. But within the Bush administration, the people who were making decisions, first and foremost, Vice President Dick Cheney, who really headed up the decision-making about how to wage the war on terror, and his legal counsel, David Addington, who I would explain briefly, can only legitimately, in my opinion, be characterized as radical right-wingers. They're not conservatives because the kinds of vision they had and that they actually produced as agents of the US government was conserving nothing. It was radically transforming certain kinds of things. They had decided right off the bat that the kinds of people we were fighting against could only be interrogated using physical violence and coercion. So that was one agenda. They had decided that none of the, sort of legal safeguards for people in custody should apply to these people, including access to a lawyer and so on. So there was a debate. Where could people be held and interrogated for long periods of time without any of the overweening, eyes of judges or the interventions of lawyers? And so ultimately, in December, Guantanamo Bay, the U.S. naval facility in the coast of on Cuba, was selected, and the first prisoners then arrived there in January of 2002. Now, again, very little of this, except for the most sort of exterior elements of what was going on in the government, was known to the public. Much of government policy making about prisoners and so on was undertaken in secret. And there was a secret debate going on in the government in the winter of 2001-2002 that pitted the State Department against Cheney, or the White House, let's say, and the other radical right-wing lawyers in this small group of lawyers in the Justice Department and in the Pentagon as well. The battle, going on in January was essentially, should the Geneva Conventions apply? Now, at that time, U.S. Secretary of State was Colin Powell. Colin Powell was one of the few people in the Bush administration who actually had military experience. He'd been chief of the joint, he'd been the head of the Joint Chiefs, et cetera. He'd been a, top general and so on, understood the laws of war. And his lawyer, the lawyer for the State Department, is regarded institutionally as the American official expert on international law. Well, they argued that the Geneva Conventions must apply. It's not contingent on reciprocity. Like, if the enemy doesn't abide by the Geneva Conventions, you can throw it out. But the group operating under, Cheney's influence did not want the Geneva Conventions to apply. And part of their reasoning was, if the president declares that the Geneva Conventions don't apply, then you can't have war crimes. No crime without law. And so, in fact, that contingent won, and on February 7th, 2002, President Bush secretly declares that the Geneva Conventions do not apply to the war on terror. And that, in a sense, opened up a license to invent and innovate the treatment of prisoners elsewhere. Now, many of the prisoners were, being gathered up in Afghanistan, and some were being shipped to Guantanamo. But the CIA's operation operation was very much tailored to looking for those people who are called, quote, high-value detainees, people who were presumed to be top leaders of al-Qaeda or to have, detailed knowledge about past or future terrorist activities. The very first person, the first so-called high-value detainee who was captured by the CIA was someone named whose nom de guerre is Abu Zubaydah. And he was captured in March of 2002, and he was subsequently moved, into a CIA black site, into various CIA black sites. Well, immediately, the contractors for the CIA who were brought in to interrogate Abu Zubaydah were given authorization by the White House to engage in all kinds of violent and, on its face, torture techniques, including, Abu Zubaydah was waterboarded, he was, protracted sleep deprivation, stripped, put in confinement boxes, and so on and so forth. Many types of activities that under any rational interpretation of the law would be regarded as torture and therefore as illegal. By the summer of 2002, some of these CIA agents were getting a little nervous about what they were doing, that they might in fact be at risk of being prosecuted in the future for violating US and international laws prohibiting torture. And so in the Office of Legal Counsel, which is an office within the Justice Department, John Yoo, who was one of the extremely radical right-wing lawyers operating in this inner circle of lawyers, authored a memo. He authored it, and then Jay Bybee, his boss, signed it. But it essentially narrowed the definition of torture in such a way that it said it is not, if things you do not rise to the level of physical torture unless they cause pain that is, in intensity equivalent to organ failure or even death. And it's not mental torture unless it causes suffering that lasts months or even years. So, for example, if someone loses the ability to speak their own language, that might be a sign of mental torture. And so that memo was produced for the CIA on August 1, 2002, to essentially giving, that was what we would say, the, quote, legalization of torture. And it was, although it was written for the CIA, which is a civilian organization, it was then passed by the White House to the Pentagon and also influences military interrogations. Now, all of this was largely secret at the time, but there were a few people early on who start either understanding things or pushing back. And I just want to highlight some of the people who were involved in this process, because in some ways, these are the people whose names should go down in history as having done something before anyone else was doing it. So lawyers associated with the Center for Constitutional Rights, from the time when President Bush had issued his executive order and then the first prisoners got to Guantanamo, one of the first things, at least that they were aware of, was that prisoners were being denied the right of habeas corpus. Habeas corpus is a common law right. It dates back to the Magna Carta, and it basically obligates a government to show cause for why someone is imprisoned. In other words, you can't just throw people for no reason and no explanation into prison. And so they brought, in February of 2002, the first habeas petition on behalf of some of the Guantanamo detainees, an Australian and several British people whose identities were known. Most Guantanamo detainees' identities were completely secret, but those people's identities were known because of their family figured out that they were there. So that we'll come back to that case. Now, as I mentioned, the torture memo that was written for the CIA and passed on to the Pentagon influences the way in which the Pentagon conceives of interrogation policy down at Guantanamo. And in fact, in the fall of 2002 and into 2003, they started, the Secretary of Defense was approving interrogation techniques that, essentially would have been violations of the laws that govern the military, Uniform Code of Military Justice, including the use of dogs and stripping and religious humiliations and various forms of beating and so on. Now, when the four lawyers, the top lawyers in each branch of the US military finally saw the draft versions of these interrogation policy documents, they were alarmed. Now, these guys are the lawyers for the army, so their clients are soldiers. And their alarm was such that they were afraid that if soldiers did these things, they would be subject to potential court-martial in the future. So these 4 JAGs, again, behind the scenes, pushed back against the Pentagon's leadership, saying we cannot possibly endorse these things. And what the lawyer for the Pentagon did was contacted John Yoo in the Justice Department, and in March of 2003, he wrote another memo essentially repeating the memo he'd written for the CIA, and the Pentagon used that to silence the top JAGs. But they were still concerned, but everything was classified. So they didn't know what to do. So they went and they met with Scott Horton, who is an international law expert, and a military law expert, lives in New York City, and at the time was head of the International Law Committee of the New York Bar Association. Now, these guys had to speak hypothetically because what they were talking about was secret and classified. But, to my understanding, they would say something to the effect that what would be the circumstances if uniformed soldiers in a country that is signatory to the Geneva Conventions were to engage in, they might give some hypothetical scenarios. Horton protected and preserved their, the classification they were alluding to, but he then banded together with a bunch of legal intellectuals in New York, and they produced a policy document basically saying what is legal in this kind of a war that the United States is engaged in terms of interrogation and detention. And that comes out in early 2004. Now, meanwhile, down at Guantanamo, the Bush administration was getting a lot of flack for Guantanamo and for the military commissions, that had not yet started working, but allied countries and others were, somewhat critical of this, and certainly the bar associations in the United States. So the Bush administration wanted to have a couple of quick cases move through. But of course, for a legal system, anybody who's going to be prosecuted must also be defended. And so some military lawyers were assigned to be the defense lawyers for the first Guantanamo detainees who were tapped for prosecution. And these are several of the first group. The expectation on them, as they were told by the Pentagon, was plea bargain these guys, let's just get a couple quick sentences and show that this system is working. Well, what these lawyers did, in a fashion that was perhaps unexpected by the Pentagon, but shouldn't have been, was that they behaved like lawyers. Lawyers are trained in the law, and they are schooled in legal ethics. And when they started talking to their clients and realizing how their clients had been treated, and realizing the kinds of rules that would be applicable in the military commissions, they started fighting back. I mean, they fought the government in the military commissions, and the guy on the left, Lieutenant Commander Charles Swift, took the fight a little further, and I'll come back to him. But as I was saying, much of what was going on with prisoners was secret. I mean, there wasn't much that was actually known about how people were being detained and treated, or who was there. And I just want to point out, again, a couple of people among, certainly more than just these folks, but these are some significant interlocutors early on. So Gabor Rona was working for the International Committee of the Red Cross at the time of 9/11 and into the first year or two. One of the jobs of the International Committee of the Red Cross, one of their duties and rights, they hold the Geneva Conventions, is they have the option and the opportunity to go and visit prisoners who've been captured in war. But the way in which the ICRC gets that opportunity is by agreeing with any government that whatever they see and learn from the prisoners, they will not publicize. They'll only make sort of off the books recommendations to the custodial government. Well, Rona got quite frustrated because he was seeing things, at least in military detention facilities of the US, understanding what was going on, and then frustrated at what the US government was proclaiming to the public. We are treating these people in a humane manner, et cetera, et cetera. He got frustrated, quit the ICRC, and then joined Human Rights First. And as such, he was one of a very prominent expert in international humanitarian law, the laws of war. A lot of people who were starting to get involved in this work aren't experts in the laws of war. And so in some ways, it was like this slowly growing movement of lawyers and others got themselves a professor of sorts. Now, the American Civil Liberties Union Union is an organization in the United States whose primary mandate is to ensure that the Constitution is respected. So the ACLU had never previously had any experience dealing with international issues or international law. But they start understanding that the Bush administration was making constitutional arguments to justify what it was doing overseas. And specifically, the kind of argument the Bush administration was making publicly was that the president, as commander-in-chief, has unfettered powers to do whatever he wants and needs to keep the country safe. And they realized, and slowly investigative journalists were beginning to, understand that there was actually, straight up torture going on, forced disappearances, et cetera. So the ACLU decided they needed somebody with experience litigating and dealing with cases of torture. Jamil Dakwar is a Palestinian citizen of Israel, and of course, Israel is the first state in the world to legalize torture in 1987, although its Supreme Court then rolled that back in 1999. But Jamil had experience dealing with Israeli torture Palestinians, and so he is brought into the ACLU, and he currently directs the ACLU's Human Rights Program. Another means by which to gather information is by submitting Freedom of Information Act requests for government documents that are unavailable. And basically all government documents pertaining to prisoners was unavailable at the time. And so the ACLU, and particularly Amrit Singh and Jamil Jaffer, spearheaded a sort of massive ongoing campaign to seek documents about who the prisoners are, how they're being treated, under what circumstances were they captured, et cetera. And this was, in a sense, an ongoing process, which still goes on. And I would say that the single best database of all the documents that have become released, declassified, et cetera, are available via the ACLU on a database. It's the torturedatabase.org. Amrit Singh has subsequently moved on to the Open Society, and Jamil Jaffer now directs the ACLU's National Security Program. Human Rights Watch doesn't deal with litigation per se. Human Rights Watch is a powerhouse human rights organization whose primary function is investigating, reporting, and then advocacy. And so John Sifton at the time was the counterterrorism investigator for Human Rights Watch, and he was spending much of his time in those years basically trying to track down where is the CIA holding these people in secret, what's going on inside the Bagram prison in Afghanistan, what's happening in the forward operating bases, et cetera, et cetera. So Sifton was, a very proficient hunter for information. But the major change, a lot of that stuff had been happening sort of slowly and with a few people involved. The major change occurred as a result of three events that happened in quick succession in 2004. The first event on April 28, 2004, was the publication of these shocking photos from the Abu Ghraib prison in Iraq. And those photos caused a global scandal, let's say. The pictures of U.S. military police abusing and humiliating prisoners in various ways, stripped naked, use of dogs, etc. There were several images in that batch of pictures of dead prisoners who had died and were put on ice, etc. The photos themselves were quite shocking. But immediately simultaneous with the release of the photos was an investigative report by one of America's top investigative journalists, Seymour Hersh, for The New Yorker. And he publicized information about a leaked internal investigative report on Abu Ghraib, authored by Major General Antonio Taguba, which basically explained for the Pentagon how the Abu Ghraib, the incidents depicted in the pictures had occurred. And the way in his explanation was that unlawful interrogation techniques had been authorized for the CIA and for Guantanamo, and they had migrated to Iraq. And that was, so essentially, with this article was the first indication that this was not, as many right-wing pundits and others or politicians were saying, Animal House on the night shift. There was, in fact, traceable evidence through the Taguba report that, in fact, what was going on in prisons, of which these images were just one glimpse, was actually based on directives coming down from the White House. But the question was, What exactly was the government's interrogation prisoner policy? And so throughout May and early June, there was a lot of pressure on the Bush administration to release documents. Like, what are you doing and on what basis are you doing it? And so finally in early June, they did declassify a number of documents, including that August 1, 2002 torture memo, as well as, Guantanamo policy, interrogation policy directives. Now, and these were, called aptly the torture memos. One of the things, the photos, are worth 1,000 words, but to lawyers, legal memos are worth 1,000 words. And in some sense, when lawyers saw the kinds of legal arguments that had been marshaled to justify what was essentially a regime of torture, and the kinds of interpretations of the Constitution, et cetera, it created an incredible, anger and confusion among lawyers particularly. And then several weeks later, the Supreme Court issues its very first landmark decision. The first court, to actually push back against the Bush administration. And it was that habeas case that had been brought in February 2002 and had lost at every level, but had gone to the Supreme Court, and the Supreme Court basically vindicated the petitioners and said, Guantanamo detainees do have habeas corpus rights, which essentially meant that Guantanamo would be open to lawyers. Lawyers could then represent Guantanamo detainees to file habeas petitions in federal court. Well, it was the confluence of these, sort of events that on the night of June 28th, I'm sure all the lawyers at the Center for Constitutional Rights were out in New York drinking cheap champagne and celebrating the victory. And the next morning, they go back to their offices in downtown Manhattan. And people attested there were like voicemail messages on everybody's phones from lawyers around the country who'd been so agitated by the Abu Ghraib photos and the torture memos that people were volunteering, like, I want a Guantanamo detainee, give me a Guantanamo detainee, and that was the birth of the Gitmo Bar. Now, the one thing that was particularly, perhaps the most significant challenge, consequence with mixed results of the Bush administration's program was the challenge that Charlie Swift made against the legality of the military commissions themselves. And he joined forces with Georgetown law professor Neil Katyal and a team, a firm of lawyers from Seattle, and they actually, challenged in the Supreme Court the legality of the military commissions. And in June of 2006, they won. The Supreme Court basically said the military commissions, as established by President Bush, are unconstitutional. But even more significantly, the Supreme Court said prisoners in U.S. custody, regardless of any aspect of what their status might be, have at minimum the rights available to them in something called Common Article 3. It's common to the four 1949 Geneva Conventions, which includes the absolute prohibition against torture, cruel treatment, and outrages. And the Supreme Court reminded that violations of Common Article 3 are war crimes. Well, President Bush condemned the Supreme Court, and sort of, if anyone recalls that particular press conference, said, "Oh, outrages, that's so vague." But he also, was, agitated about the implications. And so in September of 2006, President Bush has a press conference in which he basically, for the first time, publicly acknowledges the existence of the CIA's secret program. He says detainees in that who were held by the CIA were subjected to what he referred to as alternative techniques, which were hard but lawful. But they also announced that 14 of those high-value detainees who essentially vanished into CIA custody would be moved to Guantanamo at that point. And he also announced that he was working with Congress, which at the time was dominated by Republicans, to produce legislation, which they then did, the Military Commissions Act. And so Congress gave back to the Bush administration what the Supreme Court had taken away. But one of the things about the Military Commissions Act, which has subsequently been revised under Obama, but this aspect remains, was written into the Military Commissions Act ex post facto immunity for U.S. officials, any officials who had violated the Geneva Conventions, i.e. committed war crimes, that they would be immunized after the fact. Well, as it happens as a matter of law, it's a war crime you cannot immunize war crimes. And so to immunize war crimes is a war crime. So some lawyers have argued that the Military Commissions Act is itself a war crime. Now, but the military commissions then sort of come back up and are functioning slowly, albeit only, 3 people ultimately were prosecuted in the Bush years. But in the military commissions, and this is the critical thing, of course, I mentioned people have to be represented by lawyers. Now, over the years since 2006, 2007, many lawyers have worked at Guantanamo. Some have worked, the majority have worked as habeas counsels, just representing detainees. But a number of them have worked representing, defending people who've been charged before the military commissions. So these military commissions that were under. And one of the things, I would say maybe there's 1,000 or so lawyers who've been involved in one form or another, and that's a guess, on Guantanamo cases. These lawyers come from all across the American political spectrum. We've got Republicans and Democrats and Greens, we've got corporate lawyers and death penalty lawyers and human rights lawyers and military lawyers. So they have really, politically or ideologically, nothing prior to this in common, other than the fact that they're lawyers. But something about working on these kinds of materials over the years, I could say that there's a common, the sort of common basis is that many of these people feel that what they're ultimately doing is fighting for humane treatment and against torture, cruelty, and abuse, and also, more specifically, fighting for the rule of law, and arguing that much of what they have to deal with at Guantanamo is an open violation of the rule of law. So that's been, in a sense, how they understand their own motivations at the lowest common denominator. Well, the government, both the Bush administration, and now I'll explain briefly on the Obama administration in a moment, but just to say it's continuing, the government has demonstrated nothing but utter contempt for the adversarial process. And that contempt is manifested in a number of ways, but not least of which the treatment of people who are either military lawyers assigned to represent detainees or those civilian lawyers who have volunteered or been brought on board to cases. And how does that contempt manifest itself? It manifests in many ways, but one of them is that for lawyers to even have access to Guantanamo and access to prisoners, they have to sign protective orders. Protective orders are essentially, among other things, gag orders. If they ever reveal anything about their clients' mental conditions, health conditions, past treatment, etc., they can be criminally prosecuted because that is a violation of the protective order. They are subject to, that they cannot, for example, when they go down to Guantanamo and interview their clients, they must give their notes to censors that basically review them, and then their own notes are moved to a secure facility in Roslyn or Fairfax, Virginia. And these are lawyers who come from all over the country. Anytime they want to see their own notes, they have to fly to that secure facility to review their own notes. And at the subject of criminal penalties if they don't abide by that. But another aspect of the challenges for these defense lawyers is, the United States has many, severely problematic prison system. But in terms of pretrial torture, there really is almost no experience that contemporary lawyers would have with working with clients who've been tortured until people started working in Guantanamo, and the psychological ramifications, not to mention, differences in culture and language and so on. And the way in which prisoners have been treated at Guantanamo, where guards are, routinely trying to, and frequently trying to foment suspicions by the prisoners against their lawyers. For example, it's been alleged that, soldiers would tell prisoners, your lawyer's a Jew, your lawyer's a homosexual, in order to kind of undermine trust. So there's been a constant, need to deal with people who've been brutally treated, whose fate is unknown, who's, et cetera, and who are, constantly frustrated. That's been a very big challenge for the lawyers themselves. But then just specifically on the military commissions is such as part of operating under the Department of Defense, which is, in a sense, aligned with the prosecution. That's typical, the state versus, whoever is being prosecuted. But in this particularly particular court system, the kind of imbalance this creates for the legal process, for an adversarial process, is one in which anything defense lawyers want to do, access to evidence, the ability to hire expert witnesses or bring them in, anything that they want to do to advance their case is subject to prosecution approval. And match, the money that's available, everything. And so many of the defense lawyers have said that, not only have they been denied access to the information about their clients, they can't bring in expert witnesses they want, et cetera, et cetera. So this is really something that is perverting any notion of, due process in the military commissions. I'll just say one, thing. During the Bush years, because the military commissions were so dubious, including the ability to use statements that had been elicited through coercion or hearsay and whatever, 6 military prosecutors quit because they refused to pursue charges against people on the basis of evidence that was elicited through torture. So there have been a number of ways in which people, even within the military commission system, have pushed back. Another thing was during the Bush years, there was no support for those military lawyers who were assigned to defend Guantanamo detainees, and particularly once they brought the high-value detainees in, all of whom would be potentially facing the death penalty. These military lawyers don't necessarily have death penalty experience. In the United States, death penalty experience is a very specialized category of law. And so the ACLU and the National Association for Criminal Defense Lawyers basically created a fund called the John Adams Project, named after John Adams, one of the founding fathers of the United States, because John Adams had himself defended despicable clients, that is, the British soldiers who shot at protesters in Boston. That's why they named it the John Adams Project. But the John Adams Project basically brought together teams of death penalty lawyers with death penalty experience and terrorism experience. Some people have both, and high top clearance security. So those people started working funded by the John Adams Project, and still some of them now are funded by the government. The last thing was that one of the so-called, one of the 9/11 case now has 5 suspects. It would have had 6 suspects because this guy, Mohammed al-Qahtani, was presumed to have been the 20th hijacker. He'd never been in CIA custody. He was taken straight to Guantanamo, and then they figured out who he was. But at the end of the Bush administration term, the head of the military commissions, reviewing the way in which Qahtani had been interrogated, stripped naked, had enemas pumping water into him, sort of protracted sleep deprivation, she said he cannot be prosecuted because he was tortured. And this was a Dick Cheney protege who actually used the word torture about al-Qahtani. So that's why there's only 5 rather than 6. Now, when Obama was running for office in 2008, many people, Obama campaigned on a no-torture pledge. He'd voted against the Military Commissions Act in 2006. He was talking at the time about more transparency, restoring the rule of law, et cetera. So many people, Republicans and Democrats involved in these issues, supported Obama, including, and a lot of these military lawyers and defense lawyers are themselves Republicans. But the night of Obama's election, as the story would go, down at Guantanamo, the military defense lawyers who were down there formed a conga line and danced through the tents of the prosecutors shouting, "Rule of law, rule of law." And the perception was that, the darkness is over and here comes the sunshine. And that was the optimism. And the optimism, lasted about a week or two. On the second day of Obama's presidency, he signed 3 executive orders, which appeared to be what people had been hoping for and waiting for. One was absolutely outlawing torture, including forcing the CIA, ending the CIA exception and saying all interrogations would be subject to Geneva Convention appropriate rules. A second one was he suspended the military commissions. He didn't cancel them, he suspended them. And the third was that he closed the CIA, he promised to close Guantanamo in 1 year. Now, over the coming months, what Obama did, or the Obama administration did, was they start reviewing what actually is going on down in Guantanamo, who's there, and what evidence was in fact gathered. And so by May of 2009, 5 months into Obama's presidency, he comes and he makes his first, one of two he's made in his entire two-term presidency so far, a national security speech. And he does it at the National Archives. And he basically sort of tells the nation and whoever else is watching that he inherited a legal mess. Indeed, he did inherit a legal mess. But now that his administration has reviewed what's going on in Guantanamo and tried to decide, sort of how to deal with all the prisoners there, that in fact the military commissions would not be ultimately canceled. In fact, some people, he argued, who violated the laws of war would be prosecuted in the military commissions. But, he said, people who violated or who committed acts of terrorism would be prosecuted in federal courts, because the federal courts are, in America, the court system most suited to prosecuting terrorism cases. He said that those prisoners who could be released would be, and he also very troublingly said there were some people at Guantanamo who were too dangerous to release, but against whom the government didn't have evidence to prosecute, so they would just be held indefinitely. And so, in that sense, we start getting the shape of how things are going to go under the Obama administration. In October of 2009, his administration works with Congress, and they reform, to some extent, the Military Commissions Act. So the military commissions come back up online in the fall of 2009. In November of 2009, Attorney General Eric Holder makes a press announcement. And he announces some people, including Abdul Rahim al-Nashiri, will be prosecuted in the military commissions, as would, at the time, he said, Omar Khadr, who was the Canadian child soldier. But some people, and specifically the 9/11 suspects, 5 9/11 suspects, would be prosecuted in federal court, specifically in the federal court of New York City. They would be prosecuted at the scene of the crime. And that, at the time, had the agreement of New York City and state officials and so on. But immediately after that, as for anyone who follows American politics, there was a complete hysterical outbreak of, shrill right-wing punditry saying that this was evidence that Obama does not care about American security because he was going to bring the most dangerous terrorists in the whole world into New York City, ergo, he doesn't love America. And so the Obama administration, not having the appetite for that kind of a political fight, ultimately dials it back, and they bring these guys back, and they're being charged in the military commissions. Now, there's two legal issues about these cases, somewhat different. I mean, the question about terrorism, and this is perhaps, a very significant one, is that material support for terrorism is not a violation of the laws of war. And in fact, in some previous military commission appeals decisions, the appeals court has in fact said, yeah, the people who've already been prosecuted or convicted in the military commissions were charged with violations that should never have been prosecuted in this venue. So that's essentially the problem that they're facing now. I mean, there are ways in which certainly Khalid Sheikh Mohammed, this self-declared mastermind of 9/11, and some of the other guys, could be prosecuted on other bases. But the whole question of whether or not it's legally legitimate to prosecute terrorism cases as military law violations is troubling. And what the Obama administration is now arguing is that, America has its own version of international law. So we're basically arguing that we have a domestic version of international law. How well that will fly is another thing. In the case of Abdul Rahim al-Nashiri, who is charged as the mastermind of the bombing of the USS Cole, a large naval boat off the coast of Yemen in 2000, October 2000, so the naval boat is a military object. But one of the legal questions, you can't really have war crimes if you don't have a war. And so the question is, was the United States at war in 2000? And this is actually, it may seem arcane, but many lawyers are arguing that, no, we weren't at war in 2000, or yes, we were. And so first the Bush administration, and now the Obama administration are essentially arguing, we were at war, we just didn't know it. So they are even now we're debating, like, when did the war actually start in order to justify some of the charges against people. So sometimes the government argues, the war started in 1996 when Osama bin Laden issued the first fatwa, although we didn't know it. The war started in 1998 when al-Qaeda bombed the 2 U.S. embassies in Africa, but we didn't really declare war, but we were at war nevertheless. And Clinton bombed sites in Sudan and Afghanistan, and we were at war, obviously, in 2000. But so this is actually a way in which history and politics get played out on the grounds of the law itself. Now, this is a lot of words, but let me just summarize the one thing about Eric Holder's press conference that day. Once he announces that these 9/11 guys, by the way, Nashiri and all 5 of those 9/11 suspects were held for years in CIA custody and subjected to the harshest interrogation tactics. And so a journalist asks Holder, well, you know, what about the torture that was used on these people? Because by the Obama administration, at least the Obama administration was acknowledging that what the Bush administration had did was torture. And Holder, basically, he doesn't really have an answer. I mean, in essence, his answer is, well, we're not going to use those statements. We got other stuff. Don't worry. The public doesn't know what that other stuff is, but we're sure that, we can prosecute them without the tortured evidence. And then the questioner asks, well, these people are going to want to know what happened to them. They're going to want to know about how they were treated in the CIA and why. Is the CIA or is that information going to come out? And Holder basically said, it's hard to know I don't know exactly what the defense will try to do, so it's hard to know what our response will be, but I'm quite confident that we will be successful in our attempts to convict those men. And in fact, from that period onward, what has been happening in the military commissions is basically fighting over what is lawful, what is evidence, what can be said, what can be known, what can be argued in the courts. They're all in pretrial motion phases. And so in that sense, what we're really dealing with, and let me simply put this in context, all of the torture-related cases that have been brought forward in U.S. courts, cases that have attempted to sue people responsible for torture, attempts to actually, different kinds of cases, any cases involving tortured evidence and so on, has finished. The very last front, at this moment in dealing with the legacy of torture, at least in terms of courts, is in those military commissions down in Guantanamo. And so it is, in a sense, understanding. And so defense lawyers, military and civilian, have openly said that they want to put American torture on trial. It has to be part of the trial of these people who were tortured by the CIA. And that is a very essential element. And so the question is, of course, everything the CIA does is classified, everything. And the CIA is absolutely recalcitrant in not revealing information and not providing information and so on and so forth. So it is a matter of the lawyers attempting to figure out, piece together in their own ways, what they can do and how they can use it. And let me simply say that everything, and this is the classified memories part, everything that anybody who's been in CIA custody says is presumptively classified. It is not clear whether they will be able to talk openly in court about their own memories of what happened to them in CIA custody. And if they say something in court, to their lawyers, for example, unlike a regular court where a lawyer can hear some words and then actually respond to those words actually have to be run through a censor. I mean, this hasn't even started because the trial hasn't begun yet, but everything is classified about that. And there is, in a sense, a very, constraining element to what, can be known about, how they were treated and so on. What is known about the CIA's interrogation program? What we do know is that the CIA ran black sites in a number of countries where people were held and tortured. And the CIA also engaged in extraordinary rendition, which meant kidnapping and disappearing people, sometimes taking them first to CIA black sites or to the interrogation centers of governments, usually those that have a reputation, well-deserved reputations for torture. torture. In the CIA's Extraordinary Rendition Program, 54 countries were involved, not all as sites of torture, but allowing these planes carrying kidnapped prisoners to transit across their airspace or refuel and so on. And let me just simply say that between these two phenomena, two of the people, al-Nashiri and one of the 9/11 guys, have now been identified as victims of torture by the Polish government, because one of the black sites was in Poland. And there is now a case going forward in the European Court of Human Rights challenging the torture of al-Nashiri and I believe it's bin Atash, I forget which one, in Europe. So that is one sort of piece of the torture pie. But what did the CIA do to people in custody? I mean, what is known and what the defense lawyers and their experts have put together, because the CIA is not giving them documents, based on what is known through either declassified documents or, governmental reports and so on. What do we know about what the CIA's program was? Not even just specifically to individual people, but in general. When people were held in CIA black sites, the overarching goal was to use a combination of methods in order to produce what is called learned dependency. In other words, to completely break the egos of prisoners, the presumption being that if you can break them, then you can open their heads and dine on the delicious intelligence inside of it. That was the theory. And, certainly many people have suffered post-traumatic stress disorder as a result of their treatment. But this treatment includes expectations on a regular basis that people would be subjected to one or more bouts of hypothermia, pneumonia, sensory overload, skin lesions. I mean, people were tied onto beds for days or weeks at a time. And in fact, there were doctors on hand to check the buttocks of people so that once, for example, an ass lesion would form, they would be able to take some medical remedial measures. I mean, this was part of the overarching program. Certainly waterboarding, several people were subjected to waterboarding, which is drowning someone under controlled conditions. Hallucinations resulting from protracted sleep deprivation, multiple slaps to the face, etc. So this is, in a sense, was standard operating procedure within CIA black sites, although the question is how each individual detainee on trial was treated. Now, just to say, one of the things that the defense what a defense would do, what a good defense would do in a criminal trial, is seek witnesses who can testify to elements relevant to the case, relevant to the defendant. Of course, for those people who were held in CIA custody, how they were treated in CIA custody is relevant to the defense. But of course, it's not like the CIA is offering up the names and addresses and phone numbers of those people who ran the black sites. So what happened was, when John Sifton left Human Rights Watch, he formed a human rights private investigation firm, One World. He subsequently moved back to Human Rights Watch now, but what One World did, their investigators did sleuthing work, did investigative detective work, and they were able to identify the actual identities of several dozen actual CIA agents who'd been working in Europe, the question being, were these people ones who were at the black sites? So what they did was they produced what's called a photo lineup. First of all, they sent photographers out who took paparazzi-type photos of the actual CIA agent, and then mixed them up with paparazzi photos of random people, produced them in a photo lineup, gave them to defense lawyers without telling the defense lawyers who the CIA agent is in any lineup, if there is one at all. And then the lawyers would show those lineups to the defendants. And then the lawyers would come back to One World and say, our client identified this guy. And then it'll be like, ding, 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 you hit the bullseye. Well, the only CIA agent who has ever been prosecuted in connection with torture is John Kiriakou, who was a whistleblower about torture. No CIA agents have ever been prosecuted for torture. When one of these photo lineups was found in Guantanamo, the Justice Department initiated a criminal investigation of the lawyers. So that hasn't produced any charges yet, but that is some way in which one of the governmental contempt issues. So what's the point of all this secrecy? We are the point. We are the objects of all of this secrecy. It is, the lawyers can know things, but the public cannot know it. And the onerous, the gag orders, the profound, limitations of people who have access to Guantanamo, only journalists and a handful of legal observers. Everything is classified. I mean, the CIA has still not permitted the declassification of a Senate report on the CIA's, torture program. We're waiting even for that. But the reason for this is not, one could say, people would argue, well, it's necessary for national security. How is it necessary for national security? The CIA is no longer permitted to engage in those illegal tactics. Technically, the CIA is not engaging in torture anymore. So it's not like knowing that in 2005 waterboarding was used is going to somehow provide some great, boon for our enemies. But rather, the really specific thing is that it prevents demands. If the public knows these things, it prevents demands for accountability. Demands that people who are responsible for this, officials and agents, et cetera, would actually be held accountable. And so all of this secrecy, which is onerous and is retarding the legal process in the military commissions, is in order to keep the public in the dark. And so, in fact, the government now has submitted a protective order, which is being litigated at Guantanamo, about how the defendants' memories can actually be talked about. And the government argues the accused were exposed to classified intelligence sources and methods while they were in CIA custody, and thus are in a position to be able to publicly reveal this highly classified information through their own statements. In other words, the government is essentially arguing as though the defendants partnered with the CIA in this secret operation, and the defendants don't have the authority to declassify these statements. So that's essentially what the government's argument is in trying to persuade the military judge to keep their memories and their statements classified from the public. Now, when, so these, in the courts themselves, whenever the defendants speak, anybody who's observers, not in the courtroom, but behind soundproof glass on a time delay or watching from remote things, doesn't hear, anything, for 40 seconds, but also there can be, in fact, a blackout. And in fact, the first time a judge realized this was at a hearing for Ramzi bin al-Shibh in, when his lawyer stood up in the courtroom in the military commission and began talking about the protracted sleep deprivation that Ramzi bin al-Shibh had been subjected to, specifically around the question of whether Ramzi bin al-Shibh is now crazy. And in fact, if you ask Ramzi bin al-Shibh's lawyers, is Ramzi bin al-Shibh crazy? I heard he's crazy. They will be like, I can neither confirm nor deny anything about my client's medical condition. But in the courtroom, the lawyer was talking about the sleep deprivation and its, long-term effects on Ramzi bin al-Shibh. And all of a sudden, the audio goes dead in the courtroom. And the judge looks around and looks at the translator and and then they realize that in fact the CIA, or another government agency, OGA, was basically monitoring and has a kill switch in the courtroom where it can kill the audio, unconnected to the trial, entirely to preserve the secrecy and unaccountability and impunity of the CIA. And even the degree to which the CIA is going to be able to continue blocking out audio from these trials is one of the issues that is currently being litigated. And finally, with al-Nashiri, among the many things that al-Nashiri was subjected to was he was, sort of during interrogation while naked and tied up. Agents held a automatic, handgun to his head and an electric drill and so on. So even these are the two things when the Obama administration ultimately decided that they were going to look into, that they were going to give the Bush administration and everything that had been done during the Bush years a free pass, except for those specific things that had gone even beyond what John Yoo in the Office of Legal Counsel had said was okay. And one of those things was mock execution. So al-Nashiri was subjected to mock execution. And in the end, Eric Holder decided not to prosecute those CIA agents. But nevertheless, the al-Nashiri's lawyers would like to have those CIA agents come to court and testify. They are the subject of, an internal investigation. Clearly, the government knows who did that to al-Nashiri. So ultimately, I mean, this is, in a sense, this is what the military commissions look like, where the courtroom is on the inside, and then journalists and observers are behind this kind of glass. I mean, there's no, I can't say that there's really an end to this talk because we haven't even started the trials. The trials are not even slated for another year at best. But what people who are knowledgeable in following these things would say, for example, David Glazer, who's a retired member of the military and is now one of the most prominent experts on military commissions, having studied these things for years, was optimistic when Obama came in, now is watching, basically said, you know, we should call these things what they are. What's going on down in these military commissions, this is the torture commission. The rules, the procedures, the evidence, the treatment of lawyers, etc. It is all to maintain the secrecy of past torture and to prevent that torture from being part of these trials. And Eugene Fidel, who's the head of the National Institute for Military Justice, basically has summarized quite aptly that the military commissions are antithetical to the administration of justice. They're slow, they're opaque, and the rules are currently unknown. So just to pull it back for 1 minute and one step, backwards to draw the larger picture. In the American legal system, there's a saying called the fruit of the poisonous tree. In other words, if the police or the government does something illegal at the beginning of somebody being captured and arrested, that's, and for example, beats them for a statement, anything that comes out of that, even if other things are derived later in legal ways, is called fruit of the poisonous tree. In other words, that the tree has been poisoned once you do something illegal to somebody. And in some ways, the treatment of prisoners at Guantanamo, and certainly the treatment of prisoners who are in CIA custody, is fully, a poisonous tree. Both the Bush administration and the Obama administration have claimed that by bringing in clean teams to interview people, legally later, they can get clean statements. But that's, a question. But among the things that this poisonous tree with very long branches or roots, because the United States is a big country, the fact that the United States legalized torture, and then even when it unlegalized torture, it never pursued any kind of accountability, it means that this has had an effect on international legal norms. Other governments can now say, how can you criticize us for doing things to prisoners? Look at the United States, so-called bastion of the rule of law, defender of human rights. Of course, that's not actually accurate, but people might think that. But the thing is that then you would have that be a degradation of international legal norms. Within the United States itself, the fact that judges and courts have succumbed to government arguments that cases can't go forward, that no victims of torture can find justice on the grounds of state secrets or governmental immunity. There is no immunity for torture, at least not legally. But in the United States, there has been. And it means that in this country now, or at least in that country where I'm talking about, there is a complete confusion about what is legal and what is not legal. And if you followed the last presidential election, while Obama remains committed to no torture, that can be a debatable question, but that Republican candidates argued that we should bring back the waterboard, that in fact it was a terrible mistake not to maintain waterboarding and other coercive interrogation techniques. So the American legal system as a whole has been poisoned by our legacy of torture. And the fact that no one has ever been held accountable really is something, torture is a grave crime, domestically and under international law. And what does it mean when criminals are not held to account? It degrades the law itself. And it fails to do one of the things that criminal law is supposed to do, which is by punishing people today, you theoretically deter crime tomorrow. So what will deter torture in the future when people who are responsible for torture have been unpunished? So in some sense, I think it's a very bleak story, but hopefully at least some of the tales of the lawyers who are out there challenging and trying to bring back the rule of law might be a little bit inspiring. So I'd be happy to answer any of your questions now.
Hi, I just have a question about the countries you talked about that are black spots, because in April, I think last year, OSF issued a report about those countries. Mm-hmm. I want to know how the regimes in those countries are also part of the international of the Geneva Convention and how much the governments of the black spots can be held accountable?
That's a very excellent question. First of all, torture is a universal crime anywhere. I mean, in some ways it's customary international law. But in Europe in particular, I mean, Europe has a very robust sort of regional commitment to international law, including the European Court of Human Rights, et cetera. Now, so that's just one thing. Now let me say another thing. One way we think about how states operate, states are not single-headed entities, right? I mean, states have many ways of functioning, and security practices, security agencies oftentimes operate sometimes in ways that other parts of the government don't even know. And you might have collusions among security agencies that are, run counter to what the publics in those countries would know. So certainly in Poland, in Romania, in Lithuania, in Italy, and in Sweden, where there were kidnappings, the secret services of those countries colluded with the CIA in its operations, and when the publics found out, there were consequences. So 23 CIA agents were actually prosecuted for kidnapping of an Egyptian off the streets of Milan and shipping him to Egypt. They were prosecuted in Italy in absentia, and they've been convicted. Now, the US government is not sending them off to Italy to serve their prison sentences, and the Italian government has not asked for them, but those people can never go back, those CIA agents can never go back to Europe, or any country that has an extradition treaty with Italy, which is basically every country. Now, Poland, as a fairly new member of the European Union, is in fact, proceeding with, because one of the CIA black sites was in Poland, and when that became known, and now the Polish government is, the Polish government itself is now fighting against those people in Poland who are seeking accountability from the Polish government, for allowing torture to go on in Polish territory. So you're seeing many fights over accountability and transparency also in Europe. In other places where there were black sites, I mean, Afghanistan is its own story. There were places, Egypt and so on, there have been political transitions that leave that up in the air. But one of the things that we might think about on this particular issue of torture in particular, you notice that there's no extraordinary rendition and no black sites out of Latin America. Latin America, starting in the 1960s with the Brazilian, with the Brazilian military coup and going to many other countries where right-wing military regimes, with the assistance of the U.S. government, overthrew civilian governments. And, much of Latin America was characterized as, sort of a reign of state terror across the region. Pinochet in Chile, Argentina with the disappeared, et cetera. There was not a lot of accountability in the immediate, once those military governments stepped down and civilians came back up. But starting in the 1990s, you started getting domestic processes of accountability for past torture in Latin America. And those governments have essentially refused to participate in these kinds of things. In some ways, Latin America becomes a model and perhaps a beacon of hopefulness about what may happen in the future in the United States, because they appreciate the significance of the illegality of torture.
I'm curious about what the Obama administration's practices are today. It's my understanding that the Obama administration still does rendition or participates in rendition, and that even though torture has been disallowed, it is not taken off the books. And there is certainly a theory that, in fact, the administration retains the ability to torture people if they want to. They have simply chosen not to so far, and we don't really know. So I wonder if you could comment.
Sure. I mean, the difference between rendition and extraordinary rendition. I mean, President Clinton, during his term in office, in collaboration with Egypt, sort of developed the rendition program, which meant kidnapping people and transferring them somewhere for trial. So I think that the Obama administration is now engages in capturing people, but not sending them. Extraordinary rendition was where you were sent to be interrogated, possibly secretly. Whereas regular rendition is that you might be held, maybe off the books for a very little bit of time, but your ultimate destination is a regular prison and a courtroom. So I think in that sense, it's kind of recuperating at least the Clinton era, where at least people are going to sort of come out of the light out of the darkness and into the light. As far as what is, I mean, the CIA has more or less been taken out of the interrogation business. Of course, they have their hands full with the drone business, but which they apparently are not turning over to the military, despite claims to the contrary. But the real sort of dark side now is the Joint Special Operations Command, the JSOC. For any of you who have seen Jeremy Scahill speak or read his book, Dirty Wars, I mean, he really elaborates on JSOC operations, where JSOC are the special forces, and sometimes operating with the CIA as well, but where they can go in and they're not doing necessarily replicating the CIA's program, but they are like capturing like Al-Shabaab or whoever they might think of, and there may very well be either using the torturing services of Ethiopia or whatever, or engaging in highly coercive, if maybe not, sort of the mid-level torture techniques where they're doing it in sort of temporary interrogation facilities. In fact, there were so-called temporary interrogation facility in the Bagram prison and elsewhere in Afghanistan. I think in 2009, the ICRC, this is into the Obama administration, claimed that there was in fact still torture going on, and they wanted access to those sites, and the Obama administration said, these are not detention facilities, and you have access to people who are being detained. This, what might go on, including various forms of violence, are sort of in the process of initial questioning. So we have not completely cleaned the books, and it really is now preeminently JSOC and in these kind of shadow areas of the war on terror, really moving towards Africa, the Horn of Africa, and Yemen and elsewhere, that things are still happening in that basis. And the last thing I would mention on that question about interrogation techniques, in 2006, following the revelations of, and the Supreme Court's decision, the military itself kind of cleaned up its rules for interrogation with a new sort of manual, which would be Geneva Convention compliant. But there is one appendix in that which is classified, and people argue that that appendix still allows certain tactics that human rights experts and international law experts would regard as torture, including protracted sleep deprivation and other stress positions and so on. And that's part of the confusion, like what is torture and what isn't torture. So some of it is still on the books. Appendix M is only permitted to be used under special circumstances, et cetera. We don't know the full details because it's classified.
Are they in the process to close the Guantanamo Bay?
That's an excellent question. I mean, the Obama administration, just to give you a very brief history on what happened, was Obama pledged to close Guantanamo, thought it was doable. The person that he designated as the one in charge of that process was his first White House counsel, a guy named Greg Craig, who had been working with the campaign, the Obama campaign beforehand, was very much in touch with a lot of the lawyers I had talked about, came up with was starting to develop a plan. This is back in 2009. One of the issues that he was running up against, and the State Department was, in fact, agreed with Greg Craig, was if we want other countries, allied countries, to accept some Guantanamo detainees, these other countries were like, well, why doesn't America take some of them? Like, why should we clean up your mess when you won't even clean up your own mess? So Greg Craig at the time thought, well, who can we bring in without having Dick Cheney's head explode? They were like, okay, so let's bring in some of the Chinese Uyghurs. There's a Uyghur community in Washington. It was already acknowledged that those people were absolutely innocent, there by mistake, had been, essentially arrested simply because they were in the wrong place at the wrong time. As soon as, a right-wing Republican from Congress hears about it, he makes a stink. And Obama's chief of staff at the time, Rahm Emanuel, who's now the mayor of Chicago, decides there's no political capital. He doesn't want the Obama administration taking a bath on Fox News every night. So he basically, condemns Greg Craig for even thinking about such a thing. He argues the only way we can close Guantanamo is if we work with Republican Senator Lindsey Graham. Lindsey Graham likes Guantanamo. He likes the military commissions. Maybe we can get rid of some of these, cleared prisoners prisoners, but that's it. It hasn't really moved, much beyond that. I mean, there are, at present, 84 prisoners of the 164 who are at Guantanamo have been cleared for release. They've been cleared for release. They've been sitting there for years, but they haven't been released. Partially because Congress, in a bipartisan way, has set up so many obstacles that the Secretary of Defense has to cut his wrist and write in blood, this person will never, ever, ever pose a threat to the United States again, which of course no one can do. Some of them, really could be sent back to their home countries or sent into custody in their home countries, whatever. But there are a lot of onerous, clearance issues. And Obama himself, tied his own hands when, right in the end, I believe, is the very, very last days of 2009 or the very beginning of 2010, following the so-called underpants bombing attempt, where some Nigerian guy attempted to light his underpants on fire or blow up himself on a plane, and it was understood that he was motivated by the now executed Anwar al-Awlaki in Yemen, that Obama said that of the majority of detainees at Guantanamo are from Yemen, 53 of them who've been cleared for release, but Obama said nobody's going back to Yemen while the situation in Yemen is so unstable. So now theoretically, and then there was a big hunger strike last spring where 106 detainees went on hunger strike just protesting, and Obama then once again in May of 2013 recommitted himself to trying to close Guantanamo, but it's not really moving anywhere. And part of the larger political explanation is a lot of Americans don't know, don't care, or like the fact that there's people in Guantanamo. In fact, some people would like to have Guantanamo enlarged and send more people to Guantanamo. So there's no political consensus about Guantanamo among the American public. Moreover, there's no constituency except lawyers and human rights activists and some intellectuals who really are paying attention to what's going on in Guantanamo. So there's no domestic constituency that is putting pressure on the government, and the Obama administration has enough pressure with, the Affordable Care Act and, his promise of immigration reform. They don't want to expend political capital doing things that will make them take a bath on Fox News every night. And so Guantanamo is just, sort of an ongoing dilemma and problem, and I don't see any real action happening to close it anytime soon. Yeah.
That was perfect, because I'm going to ask you to elaborate on that a little bit about the politics of it, because there are times when you suggest that Obama has a certain direction he'd like to go in, but somebody on Fox News closes him down. But now you said something very significant, which is that there's no political will of constituency for the good side of history to emerge in the United States. And you said it's only the lawyers, small set of lawyers, who are the constituency. That's a condemnation of the whole American project, in a sense. Mm-hmm. So where is the good side of history going to come from if it can't come from the Republican Party, the Democratic Party, the American media, and now you've condemned the American public?
Well, condemn them by, inaction, indifference, and ignorance, in some sense. But, I mean, this, Guantanamo is by no means a monopoly of those phenomena. Let's think about, pardon me if it's an overly ambitious analogy, but think about, how the beginnings of the, protests against slavery. Abolitionists constituted a very small activist constituency, and there was a constituency, i.e. the South, that wanted to maintain slavery, and an indifferent North, or perhaps even amenable to the arguments of the South. And so in some sense, if we look at what's going on now, and even the role that lawyers play, many of the lawyers who've done this work feel like they've done, they've worked for nothing, because many of the things they've strived for have been losing cases. But my argument, and this is where I sort of say, if you really want to understand what lawyers do, you can't be a lawyer. You got to be a sociologist, sort of tell lawyers what they're doing, what it means. But it's like, if we think about it, had it not been for these even limited efforts, and there are a few others. There's a national ecumenical religious campaign against torture. There's some, small activist groups, Witness Against Torture, Code Pink, etc., that are certainly out there. But had these people not done what they had done, nothing would have been, I mean, in other words, this would have just been the slippery slope into the post-human rights age completely. It would have been, sort of last man out, turn off the lights on humanity. And so I would say we need, and like the Latin America case, we need to take a long view. I mean, many people in Latin America in the immediate aftermath of the military regimes might have wanted accountability, but more or less accepted the kind of let's agree to forget the past. We're living in Lebanon, right? I mean, talk about forgetting the past. But I mean, like, let's, in that sense, there may very well be a future where, the fact that even a small group of people made certain arguments consistently and with principle may very well be significant in the future. But it is a very, if one is thinking about what's happening today or tomorrow, a lot of people simply don't care. But a lot of people simply don't care about a lot of things. So I would say this is just one of many things that a lot of people don't care about. Any other questions?
Is there any precedent for the people who are deemed not guilty of anything but not able to be released? I mean, have we ever come across this in the history before?
It is, wait, I'm sorry, I'm just going to get back to the closed Guantanamo as my good. I mean, it is considered a violation of the rule of law. I mean, the notion is, in war, you are permitted to hold the enemy until the war ends. The idea is that you've removed them from the battlefield so they cannot go back to the fight. I mean, that's the principles in the law of war. Even though these people have not been classified as combatants, in theory, sort of the lowest common denominator of holding anybody has been, we're in a war on terror. So if those people who are deemed, say the 48, who can't be prosecuted but can't be released, are considered really to be soldiers in the army of Al-Qaeda, when is the war against terror actually going to end? And that's actually a much bigger political question. And it's one, for example, that a number of present and now former Bush administration officials have asked. A question that's been asked, like, when legally can we say the war ends? And what does it mean to not have this war be over? And one of the debates now among my lawyer friends is, are we going to continue to say we're in a war on terror solely to justify holding 166 people at Guantanamo? Because essentially Guantanamo as a whole would have to be, or arguments could be made that it would be closed when the war on terror ends, and they could be or should be moved to the mainland or something. And so one of the arguments is, are we actually maintaining the so-called war on terror because, like, is the tail wagging the dog? Is Guantanamo wagging this particular dog? These are, kind of debates that are happening in policy circles and among sort of government lawyers and other lawyers, but it's a question. But the notion that you can just hold people indefinitely, including especially the people who've been cleared for release, I mean, the government's position in this very, I know that Kafka or Orwell get invoked perhaps a little bit too much, but they really fit, this case, where the government's like, well, we're not imprisoning them. We're simply holding them until we figure out where to send them. They are here, they're unfree, but they're not sort of in custody, they're not in prison or whatever. So it's a very rhetorical set of arguments to kind of justify what's happening now. And the Obama administration, frankly, seeks, not completely without merit, to blame Republicans, but certainly Democrats have helped, make the same kinds of roadblocks as well. The Obama administration itself bears a great deal of responsibility for this, but there's a lot of finger pointing about, why we can't do anything. But essentially, what we are doing by not doing anything is really violating some of the most fundamental principles of the rule of law. And so that's part of what I was arguing, is that it really infects a larger, set of issues beyond Guantanamo in those 166 people.
Sorry, just one more question. The hunger strikers, have they stopped now?
The government claims that they've stopped, but according to lawyers who've been down there, there's probably about 14 or 15 who are just long-term hunger strikers still going at it.
Because I heard something the other day, it's now raised medical ethics questions of those who were forced to...
Yeah. I mean, there's a new report out that basically is looking at the role of doctors, both in CIA and military prisons, and the sort of the unethical behavior that doctors have engaged in, including an ongoing way, which is doctors participating in the force feeding of prisoners. And force feeding explicitly violates the Tokyo Charter, which is some international human rights medical charter, which says that people should not be force-fed against their will. I mean, the doctors who are participating in force feeding are in fact violating international legal medical ethics. So, there's one more question over there. Some more? Oh, yes, here.
I think in another talk you mentioned the phenomena of ghost prisoners. Have there been any consequences, legal consequences, concerning this practice, or are there still ghost prisoners?
I think people who are sort of taken into JSOC custody now may be ghosted for some period of time, although not. There's no, to my knowledge, there's no long-term detention facilities in which people are held off the books and without access to the Red Cross. But all the people who were in CIA custody were, during that period, ghost prisoners. So I don't know that, I mean, to some extent, and this is, a point of politics and argument, one of the reasons, and I endorse this position, whether other people, and there are some people who agree with me and some people maybe who don't, but one of the reasons why the Obama administration dramatically ramped up targeted killing was because of the promise not to torture and opposition to the promise not to torture, and the desire not to close Guantanamo, ergo not to bring more people into Guantanamo. And so targeted killing became a means of dealing with the war on terror. In other words, kill supplanted capture, because capture had become too politically challenging. And so while there aren't, so some of the problematic issues of torture and disappearances and kidnapping that characterize the capture process have been altered by the kill process, which is the preferred, centerpiece of U.S. counterterrorism at the moment. There's a question behind you. Oh.
When you mentioned the drones, I want to clarify. Did you mean that by decreasing the authority of CIA, they started the drones in Yemen and Africa, to increase the...
By taking the CIA out of the interrogation detention business. I mean, the CIA was already operating, the CIA and JSOC, even during the Bush administration, were doing some, sort of targeted killings. I mean, the first drone strike, targeted killing operation in Yemen was in 2002, and that was, I believe a CIA operation. But it really was that once the CIA in 2006 sort of gets out of the business of which the CIA wanted to get out of that business, of imprisoning and holding detainees, they become a crucial agency for engaging in targeted killing with drones. But the military also does so. So the CIA operates its own kill list, and JSOC operates its own kill list, and they operate in different areas. I believe the CIA has sort of, drone jurisdiction in Afghanistan. JSOC operates, I believe, primarily in Yemen. I'm not quite sure, but I believe that that's detailed in full, account in Jeremy Scahill's book, Dirty Wars. But indeed, so the CIA has been in that particular process. But even, the CIA and the Obama administration have said they want to shift responsibility for drones sort of back to the military, which the whole point is armed conflict is a military duty. And paradoxically, one of the elements of the laws of war is that civilians, the difference between civilians and combatants, lawful combatants have a right to fight, i.e. soldiers. And when they are in a war, that's what they do. And civilians have no right to fight, except under very limited and specific circumstances. Self-defense, if they form a self-defense militia or something. CIA is a civilian agency that has been engaging in paramilitary activities. And arguably, they are in every instance, are committing war crimes, because civilians are not allowed to fight. The Obama administration actually, part of the reinterpretation of the laws of war in order to justify legally what the U.S. does, has essentially argued that, that the CIA does have a legal right, to engage and be party to a war in that particular fashion. But that's one of the ways in which these international legal norms get degraded. It's like if you start giving civilian agencies the right to go around killing people, then, what's the limit, in some sense?
I think one of the most significant statistics to be understated, I just recently moved here from the U.S. I've been in the U.S. 20 years, and disclaimer, I did work for the Obama campaign in Atlanta in 2008, 2012. I'm not going to defend myself here, it's different. But the rate of conviction for these terrorist crimes, so to speak, is actually understated, even in the U.S. That narrative and that context is never actually tied into the results of what's going on. So I think it'd be interesting for the students here and those who are concerned to find out actually what kind of results these prosecutors are bringing forth.
In the military commissions?
Across the board. I think it's somewhere under what, less than 1% we're waiting. For every 100 prosecutions, there's maybe 1 or 2 convictions, and even those are sketchy.
I'm not sure what you're referring to. In the federal courts, the federal courts have prosecuted just in the last probably 10 years or so, I'm probably, nearing 400 cases of people charged with terrorism offenses. Now, one can say the U.S. government is now providing an possibly overly broad interpretation of what constitutes terrorism, but they operate in the federal courts. And so this is why many people would argue, if you want to move people through a court system, if that's your goal, is to put them on trial and then finish, as opposed to dragging things out for years, the federal court systems have a proven record on that. The reason why a lot of, for example, and it's baffling, but why, say, a number of Republicans in particular, probably some Democrats too, oppose federal trials is they operate under the illusion that military justice is tougher. You can't trust civilian juries, et cetera. But if you look at the actual conviction rates, people say, in fact, it's a prosecutorial wet dream, the federal courts. That's what even some of the, the lawyers who are representing people in the military commissions. As far as the military commissions go, after all of these hundreds of millions of dollars have been spent just on the military commissions, 3 people were prosecuted during the Bush years, and I believe 5 sentences have been completed during the Obama years. We're talking about a total of 8 people in this entire period of time, and now you've got another 6 on trial. And it's a very, very slow and onerous process. But so I hope that answers your question.
Another comment in regards to CPJ's comment about condemning the American public for putting these people into power. There is a middle ground in the U.S. who are trying to fight for the soul of the country in terms of trying to put in power the lesser of 2 evils. I worked for the Obama administration not because I thought he was the best option. It was better than having a Republican, especially after what happened with the Bush years. So there is a fight for the soul of the United States. There's whoever controls the narrative in the media, politically connected, corporate money, corporate strategies all over the place. Ms. Hajjar probably knows more than I do, but you cannot just completely condemn the entire American population because, like we have problems here, I don't think Lebanon is completely different than the United States at all. And we have politicians who lie, who cheat, strategize, manipulate the narrative. It happens in the U.S. So those who are more politically connected, have the influence, the power, the money, they control the narrative. And if you control the narrative in the U.S., more likely you kind of get your way, more or less. So
well, I agree with you completely. And in fact, for people who've had me as professor or people who, even these kinds of public talks are very much, I take a position, it's not a common one. In a sense, I'm a vicious progressive. That's a fairly paradoxical position. But I believe in naming names, ridiculing, mocking, and humiliating people in power for being stupid. And I believe that the American public may be, because, America's a tough country. It's if you mock and ridicule people, that in fact actually, can win your, people to your side. I don't think ever championing victims and, playing, the violin story, that's not particularly appealing to Americans. You gotta be a vicious asshole in order to make your point. And I try, so.
I won't say that's successful. I want to comment on the same issue. A number of people have suggested that one of the purposes of Guantanamo and of torture, and indeed making it all public. I mean, as you hinted, you know, the CIA has perhaps been doing it in Latin America for a very long time. But we don't talk about it, but now we're talking about it and we're making it all public. And so I guess my question partly is, what's behind that? Is it partly that, well, the American people were in a mood for revenge, and well, there it is. We wanted that revenge, perhaps. So it brings up this question about, yeah, well, what about the mood of the American public in regard to this? And then, you know, the justifications for torture and for detaining people all seem to be, you know, about giving information rather than demonstrating, you know, don't resist us or something, you know, about, you know, sending out a message, and not just to the Americans, but, you know, beyond the borders of the United States. I guess one of my questions is, therefore, when the people who are initiating torture are thinking about why are we going to do this, are they thinking about influencing minds, and how are they thinking about influencing minds? And so then the corollary then is, well, what's happened to the public opinion, not just in the US, but around the world, in relation to all this? For instance, are Americans no longer interested in revenge? You know, gave up on that, or learned lessons?
You know, I mean, that's a big and complex and interesting question. At the general level, I mean, obviously in the immediate aftermath of 9/11, and for some years on, especially when, you know, the war in Iraq was at its peak, and then, you know, sort of the surge in Afghanistan, there's a sense that, you know, for a general public, that we were at, you know, and this is driven by certain, you know, media narratives and others, that we are in an existential fight, you know, for survival. I mean, terrorism is depicted in this kind of existential way, which, of course, then confounds and confuses people who actually have to, like, be dealing with it on the ground. And so, for example, you know, early on in my research, I would be talking with, you know, people, not academics, not lawyers, about the work, and they'd be like, well, you know, they did that to us, so, you know, so what if we, like, throw them in dog cages down in Guantanamo? It's like, look, what, you know, you think that's worse than 9/11? And it's this notion of, like, do you understand the concept of collective versus individual guilt? And, you know, but it's, you know, one can just, in that regard, see, you know, a fertile American collective imagination for Islamophobia, for public paranoia. I mean, America has a history of, like, you know, resurgent episodes of political paranoia. I mean, going back to the founding, in a sense. So in some sense, the war on terror really plays well with a long tradition. I mean, we were fearful of, you know, all kinds of people, or our forefathers were fearful of all kinds of people in the past, Catholics and so on. Now, when it comes specifically to the interrogation, the decision-making, and this comes back perhaps to the comment that the previous gentleman had made, you know, Dick Cheney and the small group of people around him had no experience with interrogation, no experience with military law, etc. They were persuaded, for whatever reasons, that only violence would work, that they wanted actionable intelligence, and they were convinced that to get this desperately needed actionable intelligence about this ill-understood organization called Al-Qaeda and its, you know, brethren Islamist organizations, that the only way we could do it is through violence. And when they were getting, you know, early on advice and counter, you know, recommendations from knowledgeable military interrogators, from professional interrogators, from others, saying this is not actually effective, those people, the smart people, were excused. In fact, Colin Powell was basically barred from the kind of principle, the meetings of principals, because of his resistance to this kind of program. So people who actually knew things about international law, about effective interrogation, et cetera, were barred. And then you start engaging in all of this kind of violent interrogation techniques that were secret. But once they become public with the torture memos in 2004 and thereafter, you get, Senate investigations and others, you then get people justifying it. You get Bush and Cheney and others arguing over and over again that we got life-saving evidence as a result of these interrogation techniques, which ignores the fact that, first of all, the very basic fact, could any so-called life-saving information have been elicited through non-illegal methods? In other words, is the argument that you could only get it through waterboarding? But the second thing is, really? And in fact, what is conclusively known now, and I think that it will be even further confirmed when the Senate intelligence report on the CIA is declassified, is that nothing of value came out of nothing of significant, life-saving, actionable intelligence came out of those torture techniques. In fact, the kinds of information, for example, the information that led to Osama bin Laden. In the immediate aftermath of the killing of Osama bin Laden, of course, Cheney and others immediately were like, it was the water board. The water board led us to bin Laden. And then, of course, the Obama administration had to stop its victory lap for the American people and then go back and, in fact, do the counterfactual and say, no, in fact, we only began gathering through conventional methods after 2006, the information that leads us to the Courier, et cetera, et cetera. In fact, the Water Board did. But so in that sense, it's, the kinds of debates about these issues. But I think that, the long-term phenomenon of coming back to the American public is Cheney and others. And I mean, really, Cheney was a very quiet, he's Darth Vader, right? That's his persona when he was in office. But once he was out of office and, in response to the kinds of changes that Obama made in early 2009, he really went on a very public campaign, which was quickly followed by others, condemning Obama, heralding the efficacy of coercive interrogation techniques and waterboarding, et cetera, claiming that they had, produced, great information. That coupled with the show 24, where the American, mythologizing the idea that torture works, all of this persuades an uninformed American public that, in fact, these things are useful. And in fact, for the first time, it was after Obama was elected and after Obama outlaws torture and Cheney goes on his campaign that American public opinion tips into a majority, a small majority and slightly growing, that in fact, endorse the use of torture sometimes or often if it's used to prevent a terrorist attack. And there was a first time, so it very much you can see that it has nothing to do with the actual efficacy or inefficacy of these techniques or the legality. It's a malleable and not particularly well-informed public that is persuadable around stories of vicious, we gotta be tough. And so we do gotta be tough. And my toughness would be Dick Cheney is a conviction waiting to happen. So, yeah. One more question, yes.
Yeah, hi. I actually wanted you to comment for a little bit on sort of the slippery slope that happens with the United States in the broader sense. I mean, I realize that they are sort of take on the role of policing the world, that we are trying to rid the world of terrorism and terrorists, and that's why we're justifying torture and decriminalizing it and so on and so forth. But I wanted you to sort of speak generally about the slippery slope that causes and who's really policing the police here in these circumstances. I mean, who is looking after them? If they're constantly sidestepping these conventions, the rule of law, these customary norms that have been put into place. I mean, there's treaty upon treaty, convention upon convention that speaks to these sorts of things. Does it not reach a point where states can essentially say, it just leads the world into great chaos, would it not? I mean, who's going to say, sovereignty aside, that they could do whatever they want to do, essentially. Mm-hmm. Right? We are a sovereign state, we can do whatever it is that we want to do, which means torture and so on and so forth. And how does that, what is the broader implication of that in terms of other states and their relations with other states?
Mm-hmm. Well, that's a huge question, but let me just, but let me just give you the example. I mean, one, if you want to take away one bullet point, it would be that torture was the gateway violation. And it shortly after the early, immediate post 9/11 decisions to use and embrace torture, you see the beginnings of the NSA spying operations that come, and many other things that proceed from there on. And so, in some sense now, if you even just look at the kind of scandal, or sort of scandal that's arisen out of the evidence that, for example, Edward Snowden has made public through his NSA document leaks about the incredible breadth and scope of and depth and of a global nature of NSA spying. And then the Obama administration arguing we only do what we need to do. I mean, who defines these needs? I mean, in some sense, the idea that we need to do certain things to keep ourselves safe, these are the same arguments that were utilized for torture and are now utilized for much broader arrays of activities. One thing I would say, again, coming back to the question of the American public, and then I'll conclude on an international point, but the American public is, if Americans may not really care about, Muslims in Guantanamo, perhaps more Americans are capable of caring about the government's spying on them, and the kind of those uses. And if one then can, or if people can then draw the connections, that it is in fact, it traces back to the same kinds of interpretations of what is security and what are governmental prerogatives. And you could say that spying on citizens and, the long-term, lawless detention of people are in fact rooted in a similar set of circumstances. It may possibly nourish a kind of critique down the line. But I would definitely also say that, perhaps one of the upsides, the downside is that the United States has global power and influence, for better and worse. And, and so there's been a very negative influence in terms of the torture issues. But to some extent, having the U.S. government so clearly engage in what are illegal activities, and even now with the Obama administration, the spying of a different variety of sort of at least dubiously legal, if not flagrantly unlawful, it actually sort of takes America off the pedestal that it may have wanted to be on. And in some ways it actually possibly, I mean, this is me being optimistic now, creates a kind of dialogical set of circumstances where citizens in different countries may in fact expect, including the United States, may expect and demand more of their governments in terms of privacy rights, rule of law, and so on. So if anything, I mean, sometimes, the better things grow out of worse things. And so if one says that torture is bad, global spying is bad, then who knows, we can only go up from there, right? So thank you all very much for coming.